This first chapter is probably the most essential for those of us who haven't really studied law. The purpose is to ensure that we understand the basic workings of the legal system, what the sources of law are, and how the development of law is a dynamic process. The primary source of law here in the United States is the U.S. Constitution. However, each state or territory in the U.S. also has its own constitution, in addition to the federal constitution. The state constitutions must meet the federal floor. A state constitution can be more protective, but not less protective than those rights that were established in the federal constitution. There are constitutional provisions that are the basis for IDEA and the basis for Section 504 and the ADA, and those are the spending clause of Article 1 and the 14th Amendment, which has to do with equal protection and due process. You might be asking, is there a federal constitutional right to education? Not exactly. The Supreme Court ruled that education is not a fundamental right under the U.S. Constitution, but there are some federal constitutional protections for education under the equal protection and procedural due process provisions of the 14th Amendment. So in addition to some federal protections, all states have provided for public education by state constitution, by statute, or both. So states must comply with due process and equal protection clauses of the 14th Amendment as well. The major federal statutes applicable to special education are the Individuals with Disabilities Education Act, the Americans with Disabilities Act, and Section 504 of the Rehabilitation Act. It's important to remember that regulations and guidelines must fit within the general framework of legislative policy. They're promulgated because the legislative bodies can't easily develop the details of the broad policies. And as long as these guidelines are within the framework and have been developed pursuant to the applicable notice and comment requirements, they're usually given a great deal of deference by policymakers and the courts. There are federal and state regulations for special education. The federal regs provide the detail for the procedures and programmings, and states must have their plans submitted for approval in order to qualify for funding under IDEA. A few terms. Case law is law developed by the courts, and common law is early case law that was developed before there were many statutes. Dicta are pronouncements that aren't essential to the decision, but give guidance on how the court should decide future cases that are similar. Stare decisis is a concept that says the previous decisions need to bind other judicial decisions in the same jurisdiction. If it's not followed, the court has to justify why there's been a change. You need to know that both state and federal judicial systems are organized by a set of trial courts with different levels of appeal, and the U.S. Supreme Court is the highest court in the United States. At the trial court level, facts are tried. The decision can be appealed to an appellate court and ultimately to the Supreme Court of the U.S. As you move through this course, you'll want to also think about the major issues that still need to be addressed, like funding for expensive placements and the relationship of No Child Left Behind to special education and discipline for students with disabilities, or the relationship between IDEA and ADA and 504. You might also want to do a little research on the history of special education in our state. You should know that some states did have elaborate and high-quality programs of special education before 1975, and they were in fact models for developing IDEA regulations. I hope you enjoy this first module, and I look forward to working with you this term.